Hello, and welcome to McKenzie Friend. Today we're going to look at the child's views in parenting orders. But first, the usual disclaimer. Whilst I hold a law degree majoring in family law, I choose not to practice nor sort of mission. Therefore, any information cannot be relied upon. Any specific questions should be directed towards an accredited family law specialist. Now, let's first turn to the legislation. We know under Section 60CA, in deciding whether to make a particular parenting order in relation to a child, a court must regard the best interests of the child as the paramount consideration. You'll find that in all parts of family law. There will always be a best interest consideration. Now, today we're going to particularly look at Section 60cc3a, which is an additional consideration of the child's best interests. And it involves any views expressed by the child and any factors, such as the child's maturity or level of understanding, that the court thinks are relevant to the weight it should give to the child's views. Now, to understand what this means, we should turn to case law. We know that views and wishes may be read interchangeably. Also, when determining the views of a child, it must be by proper means. This means it is insufficient that a parent just asks a child, "What do you want?" to put in parenting orders. No, these views must be undertaken by someone who is independent of the child, so the child is not acting under undue influence or dictation. We also know from page 33 of the Australian Law Reform Commission Review of the Family Law, issue paper 48 by the Australian Psychological Society, children should not be required to express their views in front of parents who are in dispute over care of them. Now, I bring this issue up because recently I was dealing in a matter whereby a parent had taken a child to a psychologist, and in the presence of the psychologist and the parent, the child expressed a view that they did not want to see the other parent. Now, this parent is using that report to argue that the other parent should not see the child. Now, clearly, that was not undertaken by proper means. The child could have been subjected to undue influence or dictation by that parent. This also raises an issue of admissibility of that report. Material that is irrelevant, unfairly prejudicial to a party, or be misleading or confusing, or cause or result in undue waste of time, or is illegally or improperly obtained, is inadmissible. So the argument would likely in this matter will be that the material was improperly obtained. Now, in turning to more case law in R&R, Justice Baker referred to the validity of the child's wishes in Harrison and Woolard, and should consider whether the wishes of the child are not unsound, founded on improper considerations, or influenced by others. Justice Hannan's view in Doyle, weight should be given to wishes soundly based and founded on proper considerations and well thought through. Now, in Segura, the court will attach varying degrees of weight to a child's stated wishes, depending upon, amongst other factors, the strength and duration of their wishes, their basis, and the maturity of the child, including the degree of appreciation by the child of the factors involved in the issue before the court and their long-term implications. Ultimately, the overall welfare of the child is the determinant. In B&B, this approach, though lacking the certainty of a fixed age rule or cause of experience and with psychology, it should be followed in this country as part of the common law. Again, from Marion's case, the capacity to make an intelligent choice involved the ability to consider different options and consequences. Generally appears in a child somewhere between the ages of 11 and 14, though it might be earlier. In R&R, the majority decision of Justice Fogarty and Kay adopted a more mainstream approach. However, Justice Baker took a slightly different view and suggested that literature concluded that there were 4 reasons why the court should endeavour to give effect to children's wishes, unless those wishes were found to be unsound or founded upon improper considerations or were influenced by others. Again, we see the repeated concern about whether the validity of the children's wishes. Now, firstly, the children had a right to be heard in any determination of their future arrangements. The quality of a custody decision was likely to be enhanced if the child's views were taken into consideration. That the decision was more likely to prove workable if it is reached with the involvement and support of the child. And finally, There is a considerable body of psychological evidence which suggests that children as young as 7 are capable of expressing soundly based wishes as to their preferred custodian. Now, sometimes a parent will fail to abide by orders, claiming the child has expressed a view or wish not to see the other parent. Now, the court made this very clear in Gaunt and Gaunt, and later in Wilson and Wilson. The general belief of a custodial parent that access would not be in the best interest of the child did not constitute just cause or excuse for not complying with the order. The court made it clear that although the access was open to variation under the Act in appropriate circumstances, while it stood, the opinion of the custodian as to the desirability of access did not constitute just cause or excuse for interfering with the operation of the order. Which means that if you want to change the orders, then you have to go back before the court and change them. You can't unilaterally decide not to abide by them just because you perceive the child desires or wishes not to see the other parent. So, in conclusion, the views of the child will depend on the issues in contention and the child's capacity to make an intelligent choice. So if it's just something simple like how much time you spend with the other parent or some more minor issues, then perhaps the weight can be given, greater weight can be given to the child's views on that. There is no fixed age to which the court would attach weight to a child's view. Other case law suggests the court would likely attach weight to children over the age of 14 and perhaps even as young as 8, although previously mentioned even 7. The court must be satisfied that the views are valid and genuine and not subject to parental influence. I hope this helps.